Hey guys, and welcome to today's video. Today we have a sovereign citizen in court who insists on representing himself because taking a lawyer, getting a driver's license and insurance, and pretty much following the laws of the state are against his religious beliefs and God's law. Now, this is his last trial, and this time I do, in fact, have a jury trial to get a resolution. So, we're going to watch this video today, and in the next video, we're going to cover his jury trial. So, let's begin.
Okay, my next case is Andrew 2040-2730. Good morning.
Happy New Year.
Happy New Year. We're set for a pretrial readiness date. Are you ready for trial on the 15th?
I am.
Okay. And Mr. Myers, is this your case?
It is, Your Honor.
Are you ready for trial?
The people also are announcing ready for trial.
For the prosecution, any pretrial issues that we need to take up?
Just one thing from the people, Your Honor. I'm not sure if it's a pretrial issue. From what I'm seeing, I'm not 100% sure if Andrew has come to our office to pick up discovery yet. And so I just wanted to get kind of an update on that. We can give him the sheet again today, just so that we're not there the morning of trial, kind of showing the discovery in the case.
I just want to make sure that I've done a full Arguello advisement as well, because I think we had. All right, I don't think I have, so I'm just going to make sure, Andrew, that you understand. This is an advisement I'm required to give if someone decides to represent themselves. And so I just want to make sure that the record's clear. All right. That you are making a choice to represent yourself. So do you understand that you have a right to represent, be represented by counsel throughout this case?
I've been told that.
Well, thank you very much.
As far as the benefit or firsthand knowledge of communicating with any legal professionals on the matter, I really don't have experience on the matter to speak and say, yeah, I understand what that would. But I don't want to cause controversy, and I don't want to be belligerent or cause dishonor in your courtroom. And I hope that because we've all known each other firsthand since July 1st of last year, I hope that I haven't done that ever in your courtroom.
Okay, so I have some questions under the law I have to ask, so I just need to make sure that the record's clear. So do you understand that if you cannot afford an attorney, then one could be provided to you free of charge? Do you understand that? So that would be the public defender?
Okay, I comprehend that.
Okay. And so the process for applying the public defender would be you'd go over to their office, you'd fill out an application. They'd say if you make below a certain amount, then you could have that attorney appointed. Do you understand that?
Someone like Miss Alika Johnson.
Johnston, yeah. She works for the public defender's office.
Absolutely.
Okay. And so these are just questions I have to ask under the law. So I'm not trying to quiz you, but do you have any legal training?
For did I go to law school or?
Do you have any legal training at all? Any legal classes?
No. Every time they say that, I just think, if you don't have any legal training, why are you acting like you do? It's like asking someone who needs surgery if they have any medical schooling. When they say no, you ask, then why would you try to perform surgery on yourself?
Okay. And then for the failure to display proof of insurance, you're facing a maximum sentence of a year in jail, $1,000 fine. There is a mandatory minimum fine depending on how many priors you have. It's either $500 mandatory minimum fine or $1,000 mandatory minimum fine. Although the court can half those mandatory minimum fines if you provide proof of current insurance. Driving under suspension is a traffic infraction, and as well as expired license plates. So you're facing up to $100 fine on those cases. Do you understand the possible penalties that you're facing?
Yeah, what you're telling me.
Okay. How far have you gone in school?
Away.
All the way?
All the way.
Do you mean you graduated from
public school?
Yeah, just how far have you gone in school?
Well, before 2020, I was known as a master electrician. So I had completed, some stuff with Emily Griffith and had even a license as a master electrician, and was at that time, purporting myself to be an electrical contractor,
Okay. So did you graduate from high school
I
or
have,
get your GED
I have a
or
diploma from.
you have a diploma from your high school? Okay. And then Emily Griffith, for the record, is a trade school, but can also have like a secondary school beyond high school.
Right.
Is that right? Okay. All right. And then are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
I am not.
Okay. Do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Criminal law. Is this criminal case?
This is a criminal case.
Okay. I comprehend that.
Okay. And do you understand that you have a right to remain silent and that anything you say can be used against you in court?
I do not understand that because I was compelled to participate in the competency evaluation. And when they said they called, and, I really have honest phone records from Comcast, whether anyone called or left a voicemail, and they didn't call the number that we provided them. And I went to jail for that for 3 days because I didn't want it to, I wanted to remain silent and not testify against myself, but they contracted a psychologist from Canada who works on a case-by-case basis. And she basically, made me uncomfortable and threatened me and said if I'd already gone to jail for 3 days because somebody said they left a voicemail. And I didn't want to testify against myself. So as far as the right to remain silent with someone threatening me to go back to jail with like a gun in my head, I am forced to go against my beliefs.
No, you're free to believe you don't have to follow Colorado state laws. But the moment you act on those beliefs in public, you'll quickly learn that actions have consequences.
Okay. So in trial, what will happen is if you make statements, the jury can take that in consideration of what statements you're making. So during trial, if you have an opportunity to testify, and we'll talk about that in the middle of trial once there's that time for any defense case. But any statements you make in court in front of the jury, those could be used against you. Do you understand?
And I really didn't come here today either to make any statements. I didn't know that we were going to have questioning like this.
Yeah.
Where I'm still, all these questions that you're asking me, I'm answering them under duress.
Okay.
Because I'm supposed to be downstairs with Judge Gorman 7 minutes ago over the exact same stuff, and I've already done some time, and I don't want to cause dishonor. I don't want to cause controversy. I am seeking to correct my status, and I'm here by special appearance. I don't know what a fashion plea is. And last time I was with you, I was going to ask, you said a word to me if I found anything, and you used this word, and I was about to ask you what that word was or what it meant. And then that's when Mr. Myers approached me with the discovery. And so I was still trying to focus on what we were talking about or what you were saying. Do you remember what that word was? It was about if I had found anything in the time that when we'd last seen each other. And I think the word started with a D, and it was like dis.
I'd say the chances of you getting a subpoena from the Colorado Attorney General are somewhere between slim and not happening at all.
Something. Did you find any? I trust that it was like a question, but it was you were saying, I trust that you didn't find any. And
I don't remember what I said,
and
but
then that's right when Ian came up to me and
so let me just ask you these questions then. So so it sounds like you understand that at trial, if you decide to speak, that those words can be used against you. These are questions I'm required to ask because you're representing yourself, and I'll talk about the process for trial. But you should understand that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. And so do you understand that you have a right to confront the witnesses against you and cross-examine them? So in trial, the way that would work is if the prosecution calls a witness to testify, that person would get sworn in. The prosecution would ask those people questions, and then they would sit down, and their direct examination would end. That would be an opportunity then to cross-examine them or ask questions. So you don't have to cross-examine someone. The burden of proof is on the prosecution, which means that they have to prove this case beyond a reasonable doubt. You're not required to ask questions, but you do have a right to ask questions of those witnesses.
I could depose these witnesses, basically.
Well, we don't use the term depose, but you can ask them questions. Okay. And so you can ask them questions under the law as part of the trial. Do you understand that? Okay. And do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? So if you believe that someone, you'd like to bring in a witness, I'm not sure if there was anyone there with you on that day, but if there's someone that would come voluntarily, you can just ask them to come in and they could testify on your behalf. If you want someone to receive a court order, there is a process that you would go in. You'd file something with the clerk's office asking me to approve those subpoenas. If I approve them, then you would have someone not related to the case serve them. So you could have a private process server or the sheriff's office serve them and say, this is a court order to come to my trial. You could also have a third party not related to the case serve those people and ask that they be here. So do you understand that you have the right to have witnesses you choose court ordered to be here and testify on your behalf?
What do you think the likelihood would be of us summoning the Attorney General of the state of Colorado or the Registrar General of the state of Colorado, if that's relevant to the ultimate facts that got me to make the mistake that I made?
What is probably referring to is Luke 11, verse 46 and 11:52, which say, "Woe to you lawyers, for you load people with burdens hard to bear." However, the Bible is actually addressing religious lawmakers who created rules making it nearly impossible for everyday people to follow God, mostly for their own gain. But what's ironic is how they completely ignore 1 John 2, verse 1, where Jesus is described as a legal advocate for sinners. In the original Greek, Jesus is called a parakletos, meaning one called alongside as a legal helper or advocate.so, while the judge is here to administer the law today. The Bible actually encourages having an advocate by your side to help guide you through it.
So you can always file something in writing and then because you're not represented by an attorney can issue those subpoenas, but because you're representing yourself, you have to file something with the court, make grounds as to why you believe that the court should approve that subpoena. And so I would say I've never seen the Attorney General for Colorado come in and testify on a traffic case. You can always file something in writing and I can take a look at it. And let me just correct the record. Okay, go ahead.
Can I do that as the authorized representative of Andrew Lawrence?
I know that you are appearing today as if you are representing you're the authorized representative.
I'm here making a special
Mhm.
appearance. I've come here to do that.
So you can file whatever you'd like if you believe that someone can support your case, and then I'll file something in writing. That's the cleanest way to do that. I just want to clarify, I guess I said it was driving under restraint, but you're charged with driving without a valid driver's license. And let me just confirm that.
I was wondering if that was appealed to something different
Okay,
when Mr. Myers came up at our last meeting.
they need to file something in writing then. So you're moving to amend the no valid operator's license?
Your Honor, if the court wants me to write a written motion, I can totally do that.
Okay. So currently you're charged with driving under restraint. The prosecution is moving to amend it to driving without a valid driver's license. So driving under restraint means that your license has been suspended. What this charge is that they're moving to amend is to driving without a valid driver's license, which is a different charge. Do you have a position on that motion?
I haven't been offered a plea as
Okay.
far as making a decision on it.
Okay. So that no valid operator's license comes with a maximum sentence of a $300 fine, 90 days in jail. That's the maximum sentence. So I just want to explain to you kind of what you're facing, and then we've gone through that long advisement about representing yourself. Based on my advisement, do you still wish to represent yourself?
I'm not sure of the legal implications of me using the word myself. And when I'm looking at pro se, it's, is it speaks for himself?
So are you making a knowing decision to not use an attorney in this case?
Based on, yes, based on what the Bible tells me that Jesus says about attorneys. No offense to anyone.
Yes, I have a question. Will there be actual cookies and coffee for the jury this time? Not the lead-flavored cookies and glue-like coffee that the sovereign citizen downs every morning?
Okay. All right. So I'm going to find that your decision to, as I deem it, represent yourself, because you're not using the public defender, you're not hiring an attorney, is made knowingly, voluntarily, and intelligently after a full advisal of your rights that you have in this matter. I've explained how to have a subpoena based on my observations of Andrew. I make a determination that he, based on his demeanor today, he does understand everything that I've just advised him of. And so I will find the waiver of counsel been made knowingly, voluntarily, and intelligently. So the prosecution has said you have not picked up discovery, which is the evidence in the case. So we can give you information to do that, but so that there aren't any surprises on the day of trial, you should go there today to pick up that discovery and make sure that you have that so that you're prepared, okay?
Okay. I do have another case.
In front of Judge Goman, yeah. We let them know that you'll be late.
If anything goes wrong in there, how would I get the discovery? Say I was put in the dungeon?
File something with the court, and then we can talk about it on the day of trial. So I'm going to explain to you the way that trial works. And so the morning of trial, what will happen is we'll check in with everyone to see if they're ready. I would suggest that you watch a trial beforehand. I do have a trial that I believe is going on this Thursday, so you can either come in and watch. I usually live stream my trials unless the defense objects, which means that you could log in and watch the trial. So then when we're ready, the jury will come in. We'll have 12 people that will sit in the jury box, and then we will have some extra people that will sit behind the prosecution. We will ask questions, preliminary questions of everyone that are legal ways that they could get kicked off the jury. For example, we can't have someone that's a police officer serving on our jury because of the charges. So then we have and ask questions of everyone. And then we will ask questions of the 12 people individually. I ask questions of everyone, and then I turn it over to the prosecution. They have 15 minutes to ask questions of the jury to see if they're a good fit for the jury, and then you will have 15 minutes. You don't have to ask them questions, but everyone gets equal amount of time. After that point, I'll ask if there's any challenges for cause. What challenges for cause are whether you believe that under the law, this person cannot be fair. And so there have to be legal reasons for them to not serve on our jury. Once we decide the challenges for cause, if anyone is dismissed for a challenge for cause, the extra jurors that we have in the back will sit in that person's seat. And then we do what's called peremptory challenges, which means that each side gets three people that they can ask not to be on the jury without stating a reason for doing so.
How can you claim to be a master electrician without a government ID? I mean, how would anyone verify your license if you can't even prove you're who you say you are? You're literally your own worst enemy.
So what will happen is we'll go back and forth for for each party, and I'll issue a written order regarding this, but each party, so I'll say for the prosecution, you exercise your first peremptory, and then they will decide the jurors will be numbered. So if everyone's happy with juror 1 through 6 and they accept that jury, then we will have 1 through 6 on our jury. If someone says, no, I don't want number 6, then number 7 will then be on our jury. So we'll go back and forth until either party has accepted the jury as situated or they've exhausted their peremptories, meaning they've used up all of their 3 peremptories. So once we do that, then we'll have a jury. We'll take a break. I'll swear in the jury, and then we'll start the presentation of evidence. Then the jury will come back in. I'll have some instructions to read to them, and then we'll go to opening statements. Opening statements are not evidence, but they give you an opportunity to tell the jury what evidence you expect to be presented. You don't have to make an opening statement. You can also reserve any opening statement until the presentation of your case. So the prosecution makes their opening statement, and then I'll ask you if you'd like to make an opening statement. I'll give each side 10 minutes for that opening statement. Then we go to the prosecution will call any witnesses that they believe prove their case beyond a reasonable doubt. For the prosecution, how many witnesses do you intend to call?
Just one moment, Your Honor.
So what will happen is for each witness, the prosecution will ask that witness questions, and then they'll sit down. And then that will be your opportunity to cross-examine or ask questions. Again, you don't have to cross-examine them, but if you decide to do that, you've made a decision to represent yourself. However, there are certain bounds, so I can't help you through this, but I can explain to you my rulings. One of the things that people that represent themselves or don't have a lawyer, they get in trouble is they try to ask questions that are not relevant to the case in question. So there may be an objection on relevance, and I'll kind of explain to you what you have to, but you have to focus on whether you are guilty or not guilty of the offense and the charges on from that day. The other point that people that represent themselves get into trouble is that they start to argue with the witness. So just make sure that you are asking questions and you're not arguing. Okay, all right. And so then your questions will be done. The prosecution can do what's called a redirect, which asks questions that are related to the questions that came up. So they can't go through everything again, but they can clarify things that came up in cross-examination. We go back and forth until, for each witness, that same process. Then the prosecution rests, and then there will be time, I'll give you a full advisal as to whether you'd like to testify to the jury, and I'll give you an explanation of that. That would be the time to call any witnesses that you believe would help your defense, although again, you're not required to present any evidence. But any witness, or if you choose to testify, will be subject to cross-examination. So by the prosecution can ask your witnesses questions just as you were allowed to ask them questions. You will also be allowed to do what's called a redirect, which is again, if after the cross-examination is done, you'll be able to clarify anything that came up. Once you rest, the prosecution can do what's called rebuttal, which means just asking calling any witnesses that they believe rebut what came up in your case. Then everyone rests and we go to closing arguments. I'll give 10 minutes for closing argument if we are doing closings before 4, 15 minutes if it's after 4 o'clock. And then we read jury instructions, read jury instructions, then we go to closing, and then the jury will deliberate, and then we'll come back and once they return a verdict, they'll come back into court. Do you have any questions about the procedure?
All right. Looks like we're heading to trial. Unlike last time, I actually have the full jury trial footage ready, but it's over 4 hours long from start to finish. So today, I'll be cutting it down to just the key moments and should have it out for you tomorrow. Today's video is just a warm-up for the level of ridiculousness you will see in the next one. In other words, I'll see you guys there. Outro. The stupidity precursor. If you like the video, hit the like button. If not, hit dislike. Don't forget to leave a comment below and subscribe with notifications on so you never miss my content.